Welcome to SCOTUS Watch, what the upcoming Supreme Court term means for democracy. I am Trevor Potter, the president of the Campaign Legal Center, CLC, and I would like to thank all of you for joining us. CLC is a national, nonpartisan organization that works to advance democracy through law at the federal, state, and local level. We fight for every American's right to participate in the democratic process. We believe our democracy should be transparent, accountable, and inclusive. The majority of the U.S. Supreme Court has been aggressively overturning precedent in recent years, reversing decades of work by prior courts that sought to perfect and protect our democracy. The inconsistencies and contradictions on display in the current conservative majority's rulings lead to serious questions. Is the court simply hostile to democracy? Are justices in the majority aligning themselves with the political party of the president who appointed them? Are they serving the special interests that deployed dark money in support of their nomination to the bench? CLC experts and special guests, Senator Sheldon Whitehouse and Helen White from Protect Democracy, will be joining us today to discuss the current trajectory of the court and how its rulings impact our democracy. Before introducing today's panel, I would like to review a few housekeeping items. Senator Whitehouse will be with us today for about 30 minutes. To allow time for audience questions for the senator, we will have a short question and answer session with him at the end of his remarks. After the senator signs off, we will return to the panel discussion, followed by a final question and answer session with the other members of the panel. All questions for the panel can be submitted in the comments section on YouTube, Facebook, or LinkedIn. We will do our best to get to each question, but in the interest of time, we may not be able to do that. If that is so, please email info@campaignlegalcenter.org with questions you would like answered. Now, I would like to introduce today's panel. We are delighted to have with us Senator Sheldon Whitehouse, a United States Senator for the state of Rhode Island. He serves on the Finance Committee, the Judiciary Committee, the Environment and Public Works Committee, and the Budget Committee of the Senate. And he is the author of a book that will be released in October called The Scheme: How the Right Wing Used Dark Money to Capture the Supreme Court. He will be joined today by Helen White, who serves as counsel at Protect Democracy. She focuses on protecting elections and voting rights and ensuring accountability for abuses of power through litigation and other advocacy strategies. She also currently leads Project Democracy's work combating the independent state legislature theory. Paul Smith is the Senior Vice President of CLC. He has 4 decades of experience litigating a wide range of cases, and he has argued 21 cases before the U.S. Supreme Court, securing numerous victories, including in important cases advancing civil liberties. He is also a professor at Georgetown Law School. Aseem Mulji is a legal counsel for redistricting at CLC, where he serves as counsel in voting rights and redistricting cases, including the Tennessee NAACP v. Lee, Vote America v. Schwab, and Soto Palmer v. Hobbs. So I thank all the members of the panel for joining us in what I know will be an interesting conversation. Let me just jump right in with Senator Whitehouse. Senator Whitehouse, before we get into the role of the Supreme Court in democracy today, you have been quoted as saying the court is awash in dark money influence. Will you share with us how that came to be, and what impact you think it has had on ruling by the court.
Well, I think to get to the beginning of the plan, you've got to go back many years. The conservative interests have played a very long game trying to get control of the court, dating back to the infamous Powell memo, which he wrote just before going on to the Supreme Court. But that long, slow, patient, quiet effort really went into hyperdrive when President Trump was elected, and declared that the Federalist Society would be his gatekeeper for Supreme Court nominations. And at about the same time that happened, what else went into hyperdrive was dark money flowing into the Federalist Society. And of course, you can turn out of the Federalist Society's door and go right down the hall in the same building, same floor, same hallway, to the Judicial Crisis Network, which is where big dark money donations as big as $15 million, $17 million poured in to pay for the campaign ads to support, first of all, to stop the Garland nomination, and then for the Gorsuch, Kavanaugh, and Barrett nominations. And recently, the tally of the spending on the entire operation, of which FedSoc and JCN were sort of the prime components, the tally for the total thing has been lifted to $580 million spent. When you're spending over $500 million on a particular thing, A, that's a big deal, and B, you probably want something for it. So that's how the dark money problem came to wreath itself around the court. Once they're on the court, then you get to stage two, which is the dark money amici that come in and tell the dark money chosen judges what it is that they want them to be doing.
So what are some of the solutions that would help decrease the influence of dark money on the court?
Well, the court could do a lot to save itself. They've allowed a procedural fast lane to develop for cases that really don't look like real cases or controversies, in which the legal group goes and finds the plaintiff instead of vice versa, in which they come into courts asking to lose, which is pretty abnormal in courtrooms, all with a view of getting quickly to the Supreme Court, sometimes at the invitation of a conservative justice to get a case decided their way. The court does not need to provide that fast lane. The court could enforce its amicus curiae rules so that you know who's behind some group that shows up at the court. There are plenty of groups that show up that seem to have no function in life other than to mask whoever is really behind them. And they come in flotillas. So if you don't know who's behind them, it's hard to know which, are the keys on the same piano. The top record for that was probably 50 plus groups at the certiorari stage in the Americans for Prosperity Foundation case, which was essential to the dark money operation because they were arguing for a brand new constitutional right to dark money, which sure enough, 6-3, they got. So those are all things that can be done. We're also trying to clean this up legislatively. The court needs a proper ethics code. It needs some independent arbiter of its ethics, even if only advisory. And my disclosed bill that just failed in the Senate with 0 Republican support and 100% Democratic support would have actually made some of the disclosure requirements for elections pertinent to election campaigns regarding judicial confirmation. So the JCN would no longer be able to keep its big donors secret. And obviously that matters because if you've got business before the court and spent $50 or so million to influence who's on the court, people deserve to know.
So you've said that the court could start by enforcing its amici rules. What is it not doing that in your view it should be doing? And could they just start doing it, or is this something that is going to need legislation to hold their feet to the fire?
No, it doesn't need legislation, and they've actually, after stiff arming me for quite a while, they finally turned it over to the Judicial Conference to actually take a serious look at this because it is a serious matter in the circuits as well. The way they allow amici curiae to read the rule is that the requirement to disclose who funded your brief can be read to be limited to the printing, binding, and service on the parties of the brief, which is a, maybe $10,000 expenditure. So you could be a group that is wholly funded by ExxonMobil or some other entity, and as long as you had the cash on hand of 10 grand to pay for that yourself, you make no disclosure whatsoever. And so that's common with amicus curiae briefs, is no disclosure, that people just leave that blank. And the court has not adapted to a new era of flotillas of dark money funded front groups appearing in orchestrated chorus before it. So it needs to adapt to that new phenomenon.
And it would do that by requiring what? That
well, they could look at our disclose bill, which has pretty sensible requirements for how you do disclosure. If you do it stupidly, then you're like a super PAC, and all you're obliged to do is disclose the phony front group that gave you the money. It doesn't actually show you who the principal is behind the whole operation. So you'd want to model the rule on our Disclose Act, which goes all the way back to the true, what you'd call in money laundering, beneficial owner. And if they wanted to, they could do that. They'd need to give people notice. They'd probably want to be hearings. They'd want to close out the judicial conference effort and probably work off that. But it's within their power as a court to make those requirements of people filing amicus briefs.
And do you think something might come out of the Judicial Council on that now that they're looking at it?
Judicial conference, yeah. They're looking at two things, actually, mostly at my behest. And to a certain extent, I think this is the Supreme Court turfing stuff off to the Judicial Conference for a little bit more deliberation and delay. But it's good that they're working on it. It's serious. Circuit judges have said, look, we really do need to see who the power is behind the throne in these amicus briefs. And the other one is the personal hospitality exemption, which the Supreme Court seems to see differently than all the other courts and pretty much anybody else under ethics rules. And I think that got hard enough to justify they turfed it to the Judicial Conference as well.
Mm-hmm. I noticed in introducing you that you have a book coming out later this fall. Is this the principal focus of that?
It's part of it. They actually sent me a hard copy, believe it or not. So it's close enough that it's actually a physical thing and not just a editor's screenshot. So we go through kind of the long history of how this developed, how it got moved into hyperdrive by Trump, how the decisions of the court have tracked the influence of the big donors, and how the decisions of the court tracking the influence of the big donors have varied dramatically from the so-called conservative judicial theories that you would expect a conservative court to try to follow, like legendarily originalism. They're originalists of convenience.
So you think they're only originalists when they like
the outcome it brings. Yep. Look at Citizens United. The originalist opinion in that was dissent, was the dissent.
I know that's a subject that Aseem and Paul have recently written on in the context of a Campaign Legal Center review of the Supreme Court's democracy jurisprudence. Do either of you want to add anything to what Senator Whitehouse has just said? Paul, you're muted at the moment. Thanks.
Okay, I would add that inconsistency of sort of judicial approach is a big theme of our paper as well, and I think there are similar phenomena. Maybe it's the same phenomenon. When you try to look at the court's work in democracy cases, they seem very, very aggressive and activist. Sometimes they're incredibly deferential to elected bodies. The main thing that seems to explain is they always get to the anti-democratic outcome, and the outcome that, if you want to look at it in the most cynical way, seems to favor their team of the presidents that appointed them. And so this is an area where the court, I think, is at its worst in terms of how it looks. It's already difficult given that we have a court where there's 3 Democratic appointees who are liberal and 6 Republican appointees who aren't. For them then to be basically breaking down every democracy case along lines that look awfully partisan is really unfortunate. But that is a big part of what we talk about in our white paper.
Great white paper, by the way.
Well, thank you, Senator.
Good piece of work.
Now, Senator, I know that you have talked about the famous Lewis Powell memo of now, 50 years ago, Justice Powell, who was then appointed to the Supreme Court. But before he went on the court, he was a lawyer advising the Chamber of Commerce, and he advised them that they had to basically create a national apparatus and campaign to change the way public policy was thought about and to change the courts. Do you see all of this flowing from that? Do you think there actually has been a coordinated effort to change the who's on the courts and thus the outcome of how they look at cases?
I think it's been a sloppily coordinated campaign in its initial years. But I think as they began to see results from the court, they began to understand the value of it. If you look at Powell's own career, he was not a far right winger. He was not a screaming social conservative. He was on what I think progressives would consider to be the right side of a number of issues. But he was as true as a justice as he could be to the report where it allowed corporate interests into politics. And all of the major decisions allowing corporate interests into politics during his time on the court, he had a hand in either by creating the majority or being a principal author. And what we don't realize too often, because it's been a while, is that the role of corporate America in our democracy right now was not in the Constitution. It was put in by the Supreme Court. It was put in exclusively by Republican appointees to the Supreme Court. And of course, it went toxic with the Citizens United decision and the floods of dark money that followed that decision.
When you say, Senator, the role of corporations was put into the Constitution, are you thinking of the court giving them, treating them as persons and giving them First Amendment rights and that line of cases?
Yep. Starting with the Massachusetts decision with the bank being allowed to participate in the referendum, and then moving on to allowing 501c3s, 501c4s to participate without bothering to notice that they could become the front groups for a corporate interest quite readily, and then onward through decisions that CLC knows all too well. And then, of course, the sockdolager was Citizens United, and just kind of an appalling decision, but like all the others, partisan.
Well, of course, in Citizens United, Justice Kennedy famously said that even though for the first time corporations will be allowed to speak openly in elections, that shareholders would know how the corporations were spending their money and could therefore hold them accountable. And citizens would know who was paying for the advertising they were seeing paid for by corporations, and therefore could make their own judgments about that advertising.
Yeah, I got a number of problems with that. The first is that those are findings of fact. And appellate courts in our system of justice are not supposed to make findings of fact. They're supposed to defer those to the trial court. Second is they're false findings of fact. And were widely seen to be false findings of fact at the time. And events afterwards have proven. I think we're well over $1 billion in dark money in this election cycle. So it's hard to imagine that they could believe the money's going to be transparent when there's billions of dollars in dark money sloshing around. And that takes them to the third sin, which is once they knew that their false findings of fact were in fact false, they let them stand and let the dark money system roll rather than take any opportunities to clean up their act. And we gave them a few, including one that your friend and former boss, John McCain, offered them with me. The two of us wrote a brief in the Bullock case that said, you got it totally wrong. The facts prove it. Now's your chance to fix it. And they refused to grant cert. So they may want to ignore me, but they oughtn't to have ignored John McCain, who was a real expert in campaign finance and in election integrity.
Well, alas, by then, Sandra Day O'Connor of Arizona was off the court. You may recall that Justice Kennedy was asked a question about this issue at Harvard Law, and he responded, "Yes, I see all that. I don't quite know what happened. I don't know what went wrong."
Yeah, what went wrong was they made false findings of fact when they shouldn't have been making findings of fact in the first place, and then shouldn't have been making false ones, and then should have cleaned up after themselves when their error was plainly apparent.
And all of this, I take it, would be dealt with if your Disclose Act could pass the Senate. It tell us what happened last week. I know it came to the floor.
We called it up for a vote. We tried to move to it on a motion to proceed. The Republicans required cloture on the motion to proceed, which requires 60 votes, and they refused to provide one vote. So with two individuals absent for personal reasons, it failed 49 to 49. And we did not bother to bring the vice president over to break the tie because we needed 60. So having her come over simply wasn't germane. So unfortunately, the Republicans really went to bat for this dark money scheme, notwithstanding that the principle of the Citizens United decision was that dark money is inherently corrupting. And that was an 8-to-1 principle of that decision. So everybody knows it's corrupting. The Supreme Court has conceded that it's corrupting. We live with the corruption that it causes, and we can't get rid of it because corrupting forces don't want to get rid of it.
Well, a few years ago, I recall you're saying that you thought what would have to change is that there would have to be enough Democratic dark money that Republican senators were uncomfortable about it being attacked by dark money groups, and that under those circumstances, they would join you in pushing for disclosure. There has been a lot of Democratic dark money in the last couple of elections. Sounds like you're saying that for some reason that didn't persuade them to seek disclosure. What do you hear in talking to your colleagues?
That remark actually came from a Republican colleague who I was talking about this with, and he agreed that it was sickening stuff and was a toxin in our body politic. And he said, so you need to do your job and raise a hell of a lot more of it so that we have an incentive to get rid of the damn stuff, because at the moment it's all ours. So we have joined them at the dark money table, and there is a lot of Democratic dark money out there. But I think Mitch McConnell still sees two things. One, the Democratic dark money is kind of episodic and emotional. You know, people want to get rid of Trump, so they'll write a big check. His dark money is a profit-seeking venture by very powerful forces that make enormous returns on their political investment. So there's not balance in that sense. And then our donors would probably give anyway. It probably means that their colleges would come after them and say, hey, you made a really big donation to the Democrats. How about a lab for us? But that's very different than being, Marathon Petroleum or somebody like that and being outed as the person behind the ad. Because once you're outed as the person behind the ad loses its punch because people get the joke and they understand.
Yes, that is the argument, of course, made by ironically, by Justice Kennedy and others in Citizens United about the importance of disclosure, that people deserve to know who's speaking to them so they can make their own judgments on that.
Very good opinion by Judge Selya on the First Circuit on this topic several months ago, making that exact point.
Well, that's the battle. that we have. We have a question either to the senator or any other panelist who wants to answer it, which is, what can ordinary citizens do against this blatant and partisan abuse of power? The Supreme Court is so far removed from the influence of ordinary citizens. Please don't just say send money. I belong to a progressive political group where we're not allowed to raise funds from outside groups, but people seem very open to taking specific actions. So, bottom line, since the court isn't elected and is pretty distant from people, what can be done on the issues you're talking about, specifically pushing them to on their own ethics rules and requiring disclosure of the funding of amici?
First of all, I think if you're a lawyer participating in legal conversations, writing articles for your bar association, adding to the academic legal debate about this is particularly useful. I think that whenever we see polling around dark money, we see that it is hated across the board. Whether you're a Bernie bro or a Tea Partier, you equally despise big dark money forces manipulating politics. And indeed, this was the issue that Jane Mayer got that tape of, where Mitch McConnell's minions and the Koch brothers' minions were talking about an issue that was kryptonite for them. They couldn't fix with any amount of spin. That was this issue. That was dark money in politics. So it's really a question of bringing attention to it and making sure that civil rights groups understand the effect of dark money on the civil rights agenda, that environmental groups understand the impact of dark money on an environmental agenda, that clean elections groups understand the power of dark money in elections, although that's a more obvious one. But one of the things that the great Democratic cat herd of interest groups has not done very well is understand the common peril that we face, along with the country, from the power of dark money.
That makes a lot of sense.
Virtually nobody is making fun of the Americans for Prosperity Foundation case, for instance. They kind of got away with that quietly. And if you look at Americans for Prosperity Foundation, it's the 501c3 twin of the 501c4 Americans for Prosperity, which is, guess what, the Koch brothers' #1 political battleship. Mm-hmm. And nobody had more to do with putting these people on the court than the Koch brothers. So that nexus is something that people ought to understand, because it's a fairly flagrant one.
Do any of our other panelists want to add to that question from the audience?
Well, the only thing I would add is that there's a lot that the Congress can do to help fix our democracy. The court has, if it wants to hold things unconstitutional, it can push back, but there's an awful lot of things that the Congress could do to make the democracy work better, many of which were in bills that were introduced last year, the Freedom to Vote Act, the John Lewis Act. And so a very good use of somebody's time who wants to improve American democracy is to try to work hard to get a Congress that can pass those bills and will pass those bills and push them to pass those bills.
And if I could make one point on that, we don't need 60 members to do this. We probably need 52 or 53.
52 would be the right number, I think. Yeah.
Because with 52, you can find a procedural way around cloture. And what we really want to do, what drives me crazy about the traditionalist argument, is that what we really want to do is we want to get back to the filibuster. We want to get back to the time where everybody got to have their say. And once they'd ventilated themselves to the point that any further debate was redundant and not consistent with Senate procedures, then you vote. And when you vote under those circumstances, you vote by simple majority. And that's been the way of the Senate forever. And fixing quorum rules and things like that, there's a way to get there that would allow the minority to spend a month tying up the Senate, making sure its voice is heard. But then at the end of the day, when those arguments become dilatory, then you vote.
So that's not getting rid of the filibuster. That is putting the filibuster back into actual debate in the Senate.
Correct.
And yet that hasn't happened. Do you think there's an appetite for that?
Yeah, I mean, we've got 48 senators who said they would do that. And it's a rules change that you can effect with 50 senators. And if you're not really getting rid of the filibuster, then it's quite defensible, even for filibuster lovers. And, at the end of the day, it's just much healthier for democracy to have everybody have their say. And it's not going to be used all that frequently. If you set it up so that a determined minority can kill 4 weeks of floor time before they burn through their talking time and become dilatory, 4 weeks on the Senate floor is immense. That is a huge hazard. It has to be vitally important for the majority leader to be willing to burn 4 weeks on the Senate floor. So it's self-regulating in that sense. It will be only used for really big stuff.
Well, it'll be very interesting to see if those predictions have a chance at being tried out. Now,
The voters will tell us in November.
I know it's 3:00, and we promised you we wouldn't keep you past that. And you have Senate business to go to. So I just want to say thank you so much for joining this discussion, and we look forward to the rest of the panel, and we look forward to reading the book when you have more than one copy. So thank you.
Very happy to join you. Thank you for the wonderful work of Campaign Legal Center and Protect Democracy, and for the report that was put out with Aseem's and Paul's help. Well done.
Thank you very much for that. I encourage all of our viewers and listeners to look at it. It's on the Campaign Legal Center website. Now, let me ask you, Paul, we talked about the influence of dark money on the court, but beyond that, what other influences have played a major role in shaping the court into this conservative majority that we see today? What trends, if any, do you think in the court's decisions that you've written about point to this influence?
Well, thanks, Trevor. Let me start with the second half of the question. What trends are there, just to make sure we're all on the same page? As the report we've just been discussing points out, if you look at the pattern of decisions of the Roberts Court going back to the beginning of the Roberts Court 15 years ago or so, in the area of democracy, broadly speaking, campaign finance, redistricting, voting rights, the whole panoply of what makes our democracy better or worse, the striking pattern is that the court majority in case after case seems to pick as undemocratic an outcome as it possibly can. And it's adopted a posture where the best explainer of what they're doing is what is seemingly in the immediate benefit of their side of the partisan divide, which, I'm not saying that's necessarily consciously what they're doing in all cases or anything like that, but that is a bad look for the court. And it's particularly bad when you try to explain it in some other way, because you say, well, maybe it's just that they have a very conservative judicial philosophy that would explain a lot of the things that the court is doing now. But their approach to these cases in a democracy space is so inconsistent, as I suggested before when the senator was still with us. They say we can't possibly do anything about gerrymandering. We're going to let the legislature do whatever it wants in that area. We're going to accept from legislatures the claim that there's this big problem of in-person fraud that justifies lots of burdensome laws hurting the voting rights of people of color. We're just going to defer to that. On the other hand, in the area of campaign finance, the court has absolutely no interest in what Congress thinks is necessary to make the political system work better. It has its own view, and it's going to impose that view regardless of what the elected leaders of this country think is necessary. And then don't even get me started on the Voting Rights Act, which has been kind of taken apart piece by piece by a court making up constitutional doctrines to arrive at that conclusion. Now, some of this is the court is very sensitive about any law that seems to draw lines based on race to help people who have, because of historical circumstances, have less voting power and less control over the democracy than they ought to. And we're going to hear a lot in the next term about color blindness, not only in the Voting Rights Act area, but in the affirmative action area. But ultimately, the court needs to step back and do its main job, which you can make a good argument their single most important thing the court can do. Even if you're a skeptic about the validity of judicial review in general, you got to say they need to be the focused on protecting the democracy, making it work better, letting the majority have its say, not having the rules of the game distort the outcome. But the court doesn't seem to see that. And it's picking the more distortive, the more unfair rule more often than not, nearly always. And it is a bad look for the court, as I would suggest. I think I'll stop there and see whether Helen or Aseem want to weigh in, or you could just ask the next question, Trevor.
I've got a question coming, but I want to follow up on that, Paul. You said the court doesn't seem to see that.
Yeah.
Do you think they don't see it, or do you think they see it and don't care because they have lifetime appointments and they have an agenda?
This is the great metaphysical question, and about what's actually going on in the minds of justices who seem to be making decisions that have don't look particularly legitimate because they look like they're being made for political reasons. And the answer, I think, ultimately is probably people have a great capacity to convince themselves that they're following a legitimate path toward their decisions, and even though at the same time they are finding it easier to arrive at decisions that help their team. So it's a little bit of a mix of both, but we'll never know for sure.
Well, that's the question of what are they thinking and how far are they willing to go is a great one to put to Helen White of Protect Democracy in the context of the fact that she has been working hard and at Protect Democracy dealing with this independent state legislature theory. So I'm curious, Helen, if I could ask you, what is that theory? How did it come about? And what do you think the justices are actually thinking about that issue? What do we know already?
Sure. So there's a case on the court's docket for the 2022 term that the senator referenced called Moore versus Harper. And in that case, the petitioners, who are members of the North Carolina legislature, are basically asking the Supreme Court to say that they are not bound by their state constitutions when they regulate federal elections. So the federal constitution gives state legislatures the primary responsibility for setting the rules for federal elections. And the state legislatures are saying that provision of the federal constitution, when it gives that power to state, and it references legislatures, really means to say only legislatures. And they act independently of all other state actors, independently of state constitutional provisions. So that would get rid of sort of lots of protections around gerrymandering. Basic gubernatorial veto could be at risk. And so you could see sort of huge distortions, as Paul put it, of the sort of electoral system when it comes to federal elections in that case. The theory would upend about 200 years of practice, and unsurprisingly, sort of not at all grounded in the original understanding of the Constitution. States across the country in early practice sort of added state constitutional provisions regulating federal elections. So this is a good sort of place for the court to consider, are we going to be consistent originalists and say, there's just no original support for this theory, and so we reject it, or are we going to do something else? And I try to very much avoid sort of psychoanalysis of the justices and prediction of Supreme Court practice, but we do have some hints so far. This theory sort of first really hit the scene in 2000 in the Rehnquist concurrence in Bush versus Gore, and was picked up on in 2020 largely in sort of COVID-related litigation, often around like mail-in ballot deadlines, but was picked up once again in the sort of aftermath. State legislatures should be able to sort of overturn results of the election. And the justices sort of largely rejected all of those claims. They very clearly rejected sort of notions that the election had been done unfairly. But in those writings, several of the justices did indicate, sort of Justice Alito, Justice Kavanaugh, Justice Gorsuch and Justice Thomas all indicated at various times that they were interested in either adopting this theory or, in Justice Kavanaugh's case, at least sort of seriously considering it. And so we think there's some appetite among at least those justices to take on some version of the theory, which could be, state constitutional provisions don't apply at all, or state courts have to sort of be much more narrow in the way that they apply state constitutional provisions to state election laws concerning federal elections. So we could see a range of outcomes, but there is certainly a possibility that the court could adopt the theory. But, we don't know where Chief Justice Roberts, Justice Barrett, or Justice Kavanaugh will end up. And notably, the sort of topside briefs are in, and we saw no historians, no major legal academics, no legal experts, no sort of originalists. We saw very few kind of traditional conservative legal elites showing up to defend this theory. In fact, the law professor who's written the most about it, Professor Michael Morley, no amicus brief from him. So, I think there is a sort of lineup of conservatives and liberals who all think that this theory is bunk for a bunch of different reasons, but we will see what the court does with that.
So let me ask you, Helen, just to follow up on that. You said that there were not a line of, or as Senator Whitehouse referred to it, a flotilla of amici briefs on behalf of the North Carolina legislature and its theory. Were there conservative legal scholars and people that the justices would respect from the conservative world who are coming in to say, this is a problem, this is a mistake, be careful?
So just to clarify, the flotilla was certainly there. It was sort of the Honest Elections Project type groups that Senator Whitehouse referenced, but we didn't see the briefs you often see from, law professors, et cetera, on the topic. The amicus briefs in support of the respondents are due next month. And I should disclose that I am sort of very active in organizing and, in fact, in writing one of them. So stay tuned. I think, even you can see sort of in popular press and on Twitter, in fact, like Judge Ludig and Larry Tribe sort of agreeing that this theory is really bunk. So I think that broad consensus is certainly there, and it is certainly a cross-ideological sort of coalition pushing back against this theory, and certainly stay tuned for next month.
It was nice to see in the first round of briefs, the all 50 state chief justices filed a brief written by Carter Phillips, filed earlier than the other respondent briefs because it was filed in support of neither party, but arguing to the court, don't disempower us from protecting our state's democracies. And I think that could be very influential. I would hope so anyway.
I know this is a really high profile case before the court, but there are a lot of other cases coming up in this term starting in October. Aseem, can you give us maybe a look at some of the other cases that you are paying attention to, maybe that you're concerned about in the area of democracy law?
Sure. Yeah, I think, I think aside from Moore v. Harper, there's really, I think this term, one really big case that democracy advocates should be paying attention to, and that's the Merrill v. Milligan case. And that's the case out of Alabama, challenging Alabama's congressional districts under Section 2 of the Voting Rights Act. And in that case, the plaintiffs are saying that Alabama drew congressional districts that dilute the voting power of Black voters by packing them into just one district and then splitting up Black communities throughout the state among various different districts so they can't actually elect candidates of their choice beyond just that single majority-minority district. Now, this case, when the Supreme Court decided to hear the case, a number of justices stated that they wanted to use this case to revisit the legal test for how to prove a Section 2 violation that's been in place for decades. Now, the last time the court did this, in the Brnovich case, they weakened Section 2 of the Voting Rights Act in really critical ways, and that's part of a pattern of this court picking up cases regarding the Voting Rights Act and then really just decimating the law, interpreting it in ways that Congress really didn't intend. And I think the big fear with this case is that they'll do exactly the same thing again. I guess I'll stop there, and maybe Paul has some more things to say about it.
Well, there are various ways in which they will rule in that case for Alabama. It seems pretty likely they're going to rule for Alabama one way or the other. And one of the indications was they took away the second African-American majority district that had been created by the order of the 3-judge court below, 2 of whom were Trump appointees, and said, no, you can't have that second district for this year's election. So, whether they will do a kind of a reinterpretation of the test that makes it harder for plaintiffs to win, or whether they'll go all the way and say requiring people to consciously create a majority minority district is itself a violation of the 14th Amendment and you can't do it at all, we'll find out. But I'm pretty pessimistic about whether the court can actually be persuaded to go back and leave the law alone the way it's been for nearly 40 years and has had the results of providing opportunities for representation for voters of color that they simply never had prior to the amendment of Section 2 in 1982 to require an aggressive effort to find districts in which they can elect candidates of choice. It's really an unfortunate development, but it's part of this broader movement toward colorblindness that I think we're going to see in the court this term.
Oh, Trevor, you may be on mute.
It seems to me that the Chief Justice has sort of telegraphed that or laid out that line, that approach in his various opinions of colorblindness. But how does that square with the whole point of the Civil Rights Act of protecting specific minorities' access to representation? Or
it really doesn't.
Is he going to say that that's an illegitimate government purpose at this stage?
It's going to be, that just does seem to be where they're headed. They're going to say colleges and universities can't consider the race of applicants, and states shouldn't be drawing districts based on race. That seems to be the direction we're going, with difficult consequences in both contexts, I'm afraid. There's sort of movement away from any kind of affirmative legal requirement that people who have suffered oppression in this country for centuries and are still suffering the effects of that could get any kind of ability to be represented in better districts or in the classes of the elite schools of this country. This is the fundamental disagreement, I think.
Did you want to add something, Aseem, to that?
I guess I'd just say, I think, what's really troubling about this case is that, if you look at Section 2 of the Voting Rights Act and you look at the 4 decades of precedent that Paul was referring to, this should be a really straightforward slam dunk case for the plaintiffs. In the lower court, a panel of judges, including, as Paul said, 2 Trump-appointed judges, found that there's extreme racial polarization in Alabama, persistent discrimination against Black citizens in that state. And if you look at the map, you see that it splits Black communities all throughout the state among different districts. And the court also found that if the state were really just considering neutral redistricting criteria, it would have ended up with a different map, one that includes 2 Black majority districts, not just 1. And for decades, that would have been enough, and more than enough, to prove a violation of Section 2, to prove that a voting practice like a congressional map of that kind discriminates against Black people. The defendants in this case are really just saying that the Constitution doesn't allow them to consider race at all. And even though the map they drew has discriminatory effects, which Congress has specifically prohibited, they can't be made to do anything about it. So essentially what they're asking for is like a free pass to draw discriminatory, racially gerrymandered districts without any consequences. And that, I think, is the most troubling thing about this case. And it is troubling that other cases on the court's docket regarding affirmative action sort of point to a direction that Paul was saying the court seems to be headed.
And if we deregulate the legislatures to ignore the fact that they're diluting the voting power of minority voters and that they're diluting the voting power of the party they don't like, you're going to have some pretty distorted maps and very little remedy left. That's the concern between these 2 cases, the one Helen was talking about and the one Aseem was talking about.
So let me go back to Helen, because we look at polling and a range of election results when there are citizens' initiatives to create independent commissions and gerrymandering. And polling says that citizens hate gerrymandering. They don't like politicians drawing lines. They like independent commissions. Then when you turn to voting rights issues, polls show that the country is supportive of the Voting Rights Act and think it's important. And yet we have seen and are talking about the court doing things in this area and others that really is not supported by public opinion. Should the court be paying attention to public opinion? And there used to be the saying that the court reads the newspapers too. But this court seems to have made a number of decisions that are really at odds with where public opinion is. Should they be paying more attention, or is that wrong?
I think that the role of public opinion in Supreme Court decisions is like something that folks all across the ideological spectrum can like disagree on, even within their own ideological camp. So I actually think that's maybe not the right question to be thinking about, in that I think Paul put it well earlier when he said, is the court deciding things in a way that makes our sort of pluralistic, multiracial democracy created by our Constitution self-sustaining or self-defeating? And I think what the court sort of consistently does and has been consistently doing is sort of making decisions that maybe each one is so technocratic that it sort of seems like it doesn't have that much damage, or it won't do that much harm, or maybe it will. But when you look at them in the aggregate, it starts to get really hard to see how you have a sort of self-sustaining and self-perpetuating democratic democracy in the United States, and instead is sort of entrenching a certain type of minority rule. And I think you can see that in other areas of the court's practice, where specifically in issues around sort of related to executive power and accountability for abuses of power, the sort of other aspect of my portfolio, the court has really made it hard for everyday citizens to get remedies when the government violates their constitutional rights. That's really technical. But what does it mean if the government can just violate your constitutional rights and there's nothing you can really do about it after the fact? And I think that sort of creates this sort of sense that the court is, whether intentional, not intentional, some methodological error, is failing to understand the nature of the Constitution that it is trying to preserve, protect, expound, and is really sort of doing so in a way that makes it self-defeating. And public opinion will at times be in favor of or against various things that may be self-defeating, self-perpetuating. There are lots of instances where the court has been really important to protect minority rights, where if you had paid too close attention to public opinion, we would not have the kind of pluralistic, multiracial society we currently, are trying to protect. So it's a really tough question, but I think maybe one that's a little orthogonal with where the court should be, where the biggest critique of the court should be.
So, Paul, given that critique, is there a way to change the way the court is operating and the way it is thinking about these decisions? We read of proposals for term limits and proposals for additional justices and so forth. Do we just live with the court we have now, or are there things that either we could do? Well, Senator Whitehouse talked about things the court could do on its own, but those are really in terms of its own internal rules and ethics procedures and amici briefs. How should the rest of us look at what Helen has been describing in Aseem and what could be done?
Well, it's not surprising given how one-sided the court has become, and given how it sort of happened almost by accident over the past 15 years in terms of which presidents were elected, even without winning the popular vote, and how many slots they got to fill, et cetera, that people have started looking at ways to change the court itself, so-called court reform. And, there was the Biden Commission, and there are lots of ideas floating around. The one that seems most likely to be taken seriously is just adding some justices, because that's the one that's most clearly constitutional. And on the other hand, it would be a heavy political lift to get that through the Congress, even if it stays in Democratic hands. So, in terms of the short term, it seems to me the answer is to focus on the point I made earlier in our panel, which is that instead of changing the court, you need to change the law. And that the institution that is left to push back on a court that has gone far in one direction is the Congress. And it can pass lots of things to make our democracy function better in ways that the justices maybe wouldn't like, but would have to accept. My hope is that we get that 52-person Senate and a House that stays in the hands of people who want to protect democracy. There's a good phrase, Helen. And that we can go back to passing things like the Freedom to Vote Act, which would have essentially fixed gerrymandering for Congress without any constitutional challenge being available, and would have done a ton about dark money and disclosure and about voting rights and vote suppression. And if you add in the piece of the John Lewis Act that would have revived pre-clearance of laws in covered jurisdictions, we could have a much more functional democracy. And so the people need to push the Congress to do this, and they need to elect a Congress that can do this. It is almost the last remedy we have right now for the court's sort of piece by piece dismantling of our democracy.
We are nearing the end of our time, so I'm going to ask Aseem and then Helen if you have any final thoughts on this general topic and this afternoon's conversation. Aseem, do you want to dive in?
Sure. I guess I'll just follow up on Paul's point, just to say, what does that mean for citizens in American democracy? What does that mean that they should be doing? And I think it means identifying candidates, congressional candidates in particular, who are pro-democracy. And that doesn't mean candidates of any particular party. It means candidates who have made clear that they prioritize democracy and will prioritize protecting democracy when they get to Congress. It means asking those questions during the upcoming elections of the candidates who are running, and voting for the ones that align with voters' democratic values. So I guess I'll just leave it there.
Okay, thanks. Helen.
I would take what Aseem says and also say, don't ignore the states. A lot of sort of the move that the court is making is for giving a lot of power to states, state legislatures, but also other state actors. And so pay attention to state legislative races. Many of you may live in states where the state Supreme Court, even if it no longer has as big a role in election cases after Moore versus Harper, though I maintain hope, is elected by the citizens. And so I think there's a tendency in elite legal circles to focus on the federal government, the federal courts, and federal races, but don't leave out the states, because that is a huge democracy battleground that is worth and perhaps more proximate to most folks, where they may feel they have more power to do something.
Thank you. That's a good point and a good one for this panel conversation to end on. So during the upcoming Supreme Court term, the court will make decisions, as we've discussed, on matters of vital importance that could either improve our democracy or undermine it. We will all be watching and anticipating how we can respond to these challenges, and everyone on this panel is going to be working on those cases. So if you are a member of the media and have additional questions and would like more information or would like a copy of CLC's Supreme Court analysis, please email us at media@campaignlegalcenter.org. If you are a member of the public and have additional questions or would like more information, please email us at info@campaignlegalcenter.org. And if you have questions for Helen at Protect Democracy, with whom we work closely, we will forward those to her. So thank you all for participating in this conversation. Have a good afternoon, and thank you, Helen, Aseem, and Paul, for joining us today.
Thanks, Trevor.